Okay, folks, let's get started. In this video introduction, I'm going to be talking about the history of the central legal source for self-regulation of the legal profession. In the United States, lawyers, we say, are self-regulated. That's not quite true. There are various forms of regulations that are imposed from the outside, including tort law and market forces. But there is a significant amount of self-regulation that happens, and it mostly takes the form of rules that over time have been created by the profession ourselves, in the form of the American Bar Association normally. So in this video topic, I'll talk quickly about the different eras of self-regulation and the ABA's role along the way. So let's get started. Lawyers are having this ancient debate about whether we are a business or a profession. Probably the most honest answer is that we're both. But what does that distinction mean? Sociologists have studied this in a great amount of detail, and we could go into a long path to answer that question, but let's take the short path. And in particular, let's look at what Rosco Pound had to say about this. Pound was the dean of the Harvard Law School during the early decades of the 20th century and was really highly engaged with the American Bar Association and with the lawyers who were around at that time, putting together our sense of ourselves as a profession. And he described professions in this phrase you see up here as pursuing a learned art, so that's a key phrase, as a common calling in a spirit of public service. So notice that that as a profession, whether it be architects, doctors, lawyers, accountants, what have you, we share a common educational experience. All lawyers go to law school. And that we are trusted by the public to do some kind of public service in addition to the making a profit for making a living and making a profit in our business. Largely because the services that lawyers provide are complex and hard to evaluate over time. The thinking has been to allow lawyers to self-regulate rather than just depending on traditional market forces to do that regulation. And part of the self-regulation deal is that lawyers can be self-regulated, but only to the extent that they consider things in addition to profit, so long as you measure your bottom line in a way complex enough to account for the public good. Our professional responsibility rules were built on an assumption, a vision of a guild, lawyers who were a unified, a cohesive social group with similar interests, similar reactions. This vision of lawyers as a cohesive social group is nicely captured, I think, in Alexis de Tocqueville's Democracy in America in 1835. Remember, de Tocqueville came to the U.S. He was a French nobleman. He was asked to come to the U.S. to study prisons, which at that point was an American innovation getting attention around the world. And he started off to study prisons, but then he got more interested just generally in the new American democracy. And so he did deliver his report on prisons, but he also wrote what has remained one of the most penetrating, entertaining outsiders' account of a new democracy in America. Along the way, he had some very interesting things to say about lawyers. I won't read all of the bullet points here. The one I want to focus in on is this idea that that lawyers are an aristocracy, that they are, even in this highly egalitarian society, they have the mental habits of an aristocracy, even though they're not born as aristocrats. And de Tocqueville said that lawyers are temperamentally conservative, not in the political who do you vote for sense, but in the sense of having a commitment to existing institutions, being willing to work from the inside. So de Tocqueville had this vision of lawyers as being a cohesive class, really an aristocratic class, and that same vision, I think, motivated the early creators of ethics rules for lawyers. Now, this vision of lawyers as a cohesive, homogenous social group, esteemed by other groups, was never entirely true, and it's surely become less true over the years. The cohesiveness of lawyers in terms of their work experience has shifted over the years as specialization has pushed lawyers out into very different looking practices. What some lawyers do looks quite different from what other lawyers do. These days, about 3/4 of the licensed practicing lawyers are practicing in private practice. Other big chunks of lawyers are working in government agencies or for corporate entities, for nonprofit organizations, and so forth. De Tocqueville's image of a cohesive social group was also built on the fact that only white men were allowed to be lawyers at the time. They came from various social strata, but all white men, and that obviously and happily has changed. And I encourage you to find interesting, I think inspiring stories about the entry of women into the profession and African American and other racial groups. In 1867, Iowa became the first state to license a woman as an attorney. And by 1920, most of the formal legal barriers for women had been removed, but still in 1960, only about 3% of the American bar were female, so obviously the formal barriers were not the only things going on. But these days, as you know, roughly half of all students coming into JD programs are women, and that over time will be reflected in the broader profession. First African American attorney admitted to an American bar was in 1844 in the state of Maine. It was Macon Allen. And by 1890, African Americans still were less than 0.5% of the population. Today, roughly 4%. The same is true for Latinos. The American Bar Association first shows up in the late 19th century, 1878. This is happening about the same time that everybody's jumping into professional associations. So you've got doctors forming their professional associations and accountants forming theirs, teachers, engineers, social workers. Lots of professional organizations are popping up in the late 19th century, and lawyers didn't want to get left out, so they jumped in as well. The ABA itself started off as really more of a social organization. Southern lawyers loved to travel to the Northeast to resort hotels such as the luxury hotel pictured here in this postcard that's reprinted on your slide. It's Saratoga in New York. But then after its initial years as primarily a social organization, the group got a little bit more interested in law reform, developing uniform laws, and so forth. So the first ethical rules that came out of the ABA were based on a 1906 report from something called the Committee on the Code of Professional Ethics. This report was a reply to a speech by President Roosevelt, Theodore Roosevelt. So here he is. And TR had said that lawyers are in this business to protect their well-heeled clients. The reason we have lawyers is so that rich people get away with stuff. The ABA wanted to reply, and so they said, no, it's not that we're trying to get rich people to get away with stuff. And then they said, lawyers are high priests, and they are the keystones of the legal order. But they said, we do have a problem now. So we've got this influx of increasing numbers of lawyers, or just more of us. And in this setting, our traditional tool, ostracism among the brethren, the professional brethren, that's not enough. The trouble is that now the shyster, the baratrously inclined, isn't that a wonderful word? Barratry would be initiation of groundless lawsuits.
So the baratrously inclined, the ambulance chase, the member of the bar with a system of runners pursue their nefarious methods with no check save the rope of sand of moral suasion. So this world is spinning out of control. The usual, raised eyebrow among like-minded fellows is no longer good enough to stop the unethical practices. And so we need something else. We need a set of rules. So what we get is a set of the canons of legal ethics, 32 of them initially, and they are adopted by 1920, so 1908 is the original year of the canons. By 1920, these canons were adopted by courts or legislatures to regulate the bar in all but 13 states. They spread remarkably quickly. And then 40 years later, by the 1960s, there were 47 canons, up from 32, and about 1,400 formal and informal opinions from bar authorities, from courts, and so forth. And they together formed a body of precedent, gave us the first real body of law for legal ethics. The second generation of ethical regulation from the ABA came in the 1969 Code of Professional Responsibility. Notice how the name is shifting. 1908, Canons of Ethics, it was ethics. Now in 1969, the slightly more neutral term responsibility. And the interesting thing about the 1969 code is that it's divided into three different kinds of statements. The first level will be the canons. These are statements of general axiomatic norms for the profession. Lawyers, for instance, lawyers should keep the confidences of their clients. So that's the first level, canons. And then there's the level of ethical considerations. They were called at the time ECs. These were aspirational in character. So these were the kinds of things that lawyers should try to do whenever possible. But if you didn't do this, there wasn't going to be any real discipline. But then there were the DRs, the disciplinary rules, and this is the third level from the 1969 code. These were mandatory statements of the minimum level of conduct that marks the start of disciplinary action. If you cross this line, then bar authorities can come after you. So there were the canons, the kind of general rules, and then the more specific ethical considerations that were strictly aspirational, and then the disciplinary rules that were also specific, but that were absolutely required, that were mandatory. Then we get the third generation of ethical rules from the ABA, the 1983 Model Rules of Professional Conduct. And notice that the language has become even more neutral. So in this third generation, we've got a few new things going on in these rules. In the 1983 version, the drafters adopted the structure of the restatement, where you have an authoritative text of rules that tries to set out what the relevant institutions are actually saying, a descriptive statement of the rules. The authoritative text of the rules is accompanied by a non-binding commentary, just like the restatement. So in the 1983 rules, you get both text and commentary. Notice here they abandoned the three-tiered structure from the 1969 code, and there's no place in this structure for aspirational standards. So the 1983 Model Rules of Professional Conduct were mostly drafted by Jeffrey Hazard, who's pictured here to the left. He happens to be a former law school teacher of mine. He taught both professional responsibility and civil procedure to the 1Ls. He's famous for coming into class, the first day of class for 1Ls, and saying, "Good morning, I'm Jeffrey Hazard, werewolf." He was known for being quite a demanding professor, so we'll give him some teeth here. Oh, that's not very, two fangs. So anyway, Jeff Hazard is the reporter for the 1983 rules, and what does he hope to accomplish? He mostly says that we want to make these rules more realistic. We want to Stop with the moralizing. We want lawyers to be subject to law just like other groups of professionals. And in particular, he wanted the model rules to integrate other sources of legal regulation and to defer to those other sources. So, about this same time, the ALI, the American Law Institute, is trying to develop a restatement of the law of lawyering for the first time. Because courts were always issuing rulings in malpractice cases, in criminal cases, in lawyer disciplinary matters that were appealed from bar authorities. And so there is a body of law that you can restate according to the usual restatement practices. And Hazard wanted to account for that in some way and to give a realistic view of what legal institutions will require of lawyers. So he tried to embody that in the 1983 Model Rules of Professional Conduct. Notice conduct now without that ethical edge to it. It's just this is what the law requires of us. Here's an example of the differences between the 1969 Code and the 1983 rules. So under the 1969 Code, we have EC 227 over here, the ethical consideration 227, that says that a lawyer shouldn't decline representation because a client or a cause is unpopular. The model rules give you a more specific situation. The court is knocking on your door and gives you a more general standard to apply. You have to have good cause for refusal. In general, the model rules try to aim for legally enforceable settings where the rules will apply. So what do we gain and what do we lose by moving from this more morally based set of rules from 1969 to the more sort of legally enforceable rules from 1983? Would we be better off if we just said, as long as we're relying on these legally enforceable rules, would we be better off just relying on external regulation, just like doctors are regulated from the outside? Perhaps lawyers should be regulated from the outside. How would you get more public involvement in the formation of rules that apply to lawyers? Is it more appropriate to move away from this self-regulation? For instance, in New South Wales, regulation can come from an independent, something called a legal profession council, where lay members are part of the panels that describe what is required of lawyers.
So that's a very quick tour of the different historical eras of self-regulation of the legal profession in the United States. We've seen several different regimes offer us several different alternatives going forward, ranging from very informal regulation not embodied in rule, just based on peer pressure really, all the way over to more formal rules that are linked more tightly with interlocking legal controls. We'll be talking about those different strategies as we go forward. Remember, the basic trade-off here is lawyers get a monopoly on the one hand. They're the only people authorized to practice law. On the other hand, then, we expect some kind of self-regulation in the public interest, with lawyers taking some responsibility for the overall quality of justice. We'll be pursuing those themes when we get together next time. See you then.